Hello, I'm Attorney Todd Leneve. Welcome to West Virginia Gun Law. Today we have huge news about a ruling that just came out of the United States Supreme Court in favor of bump stocks, finding that the ATF's 2018 rule banning them was unconstitutional. We're going to talk about that for a few minutes here today, so stick around. In October of 2017, a criminal opened fire on a country music festival taking place in Las Vegas, ultimately killing numerous people in attendance at that event. When police entered the hotel room where he had been positioned to be able to oversee the concert grounds, they found at least one firearm equipped with a bump stock, which is simply a device that is an aftermarket addition to a rifle that allows the user to achieve a higher rate of fire than they might be able to just through ordinary firing techniques. However, that stock doesn't change the nature of the firearm. It simply allows that advantageous faster rate of fire. But as a lot of people who understand bump stocks will rightly say, there is often a sacrifice in accuracy with that kind of a device. It's more of a novelty than anything else. However, after this event, the politicians went into very predictable hyper virtue signaling mode and immediately began calling for new firearms bans, assault weapons bans, increased regulations, increased penalties, all kinds of things that we typically see from them, the say a lot and do nothing crowd, after a shooting takes place. Subsequently, in 2018, the ATF then issued a final rule on bump stocks, doing a complete about-face on their long-held position that bump stocks did not constitute machine guns, and instead in this new final rule, redefining what a machine gun is to include the function of a bump stock, the mechanical function of that device, as a part of the definition which was set forth by Congress in the National Firearms Act of 1934. Now, a quick refresher for those of you who are regulars on the channel, you know that we talk about this often, and that is that the only body in this country authorized to pass laws at the federal level is the United States Congress. An administrative agency like the ATF has no lawmaking authority. They are granted a certain amount of leeway to create rules which are designed to assist them in enforcing laws that are set forth by Congress. But the ATF on its own has no ability to create a law. However, with this 2018 final rule on bump stocks, that's exactly what the ATF did. Well, shortly after the rule went into effect, Mr. Michael Cargill, a resident of the state of Texas, surrendered two of his bump stocks to the ATF, but did so under protest, asserting that the rule was not constitutional. He ultimately filed a lawsuit in the Texas federal court system, and in 2020 had a ruling against him, finding that his claims that the rule was unconstitutional were not valid claims. And so the trial court ruled against him, but Mr. Cargill then turned around and appealed that decision to the United States Court of Appeals for the Fifth Circuit, which is the circuit court serving Texas and some other states in that part of the country. After some back and forth legal proceedings in that appeal case, ultimately in 2023, the Court of Appeals ruled in favor of Mr. Cargill, finding that the trial court's decision against him was improper and supporting his position that the ATF final rule on bump stocks was in fact unconstitutional. So predictably, the government appealed to the United States Supreme Court. The court took up that case, arguments were held, and just today, June 14th, 2024, the majority decision of the United States Supreme Court came back with a 6-3 affirmation of the Circuit Court's decision, finding that Mr. Cargill was right and that the final rule was unconstitutional. So let's take a look at a few of the key points that come out of this opinion that really is a massive, massive win for the Second Amendment community. The National Firearms Act defines a machine gun as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. That definition essentially says that in order for a firearm to be considered a machine gun, a single depression of the trigger on that firearm will produce as many rounds as it can until the trigger is released. Once the trigger is released, firing stops. But in that interim, it will continue to fire non-stop without any further function of the trigger or any further input from the user. And really, that issue of input from the user was one of the central things that was looked at in this opinion that came out today. And the court essentially says that really the key function, the key consideration is that single function of the trigger. Squeeze the trigger, rounds go out of the barrel until you release the trigger. But according to today's ruling, we get some clarification as to what a machine gun is not. Let's take a look at what the court said there. Section 5845B does not define a machine gun based on what type of human input engages the trigger, whether it be a pull, bump, or something else. Nor does it define a machine gun based on whether the shooter has assistance engaging the trigger. The statutory definition instead hinges on how many shots discharge when the shooter engages the trigger. And, as we have explained, a semi-automatic rifle will fire only one shot each time the shooter engages the trigger, with or without a bump stock. So, in looking at the opinion, the court found basically three major points that it relied on in shutting down the ATF's appeal and maintaining the decision from the lower court in favor of Mr. Cargill. Let's take a look at each one of those here briefly and see where the court's focus was on this opinion. A semi-automatic rifle equipped with a bump stock does not fire more than one shot by a single function of the trigger. With or without a bump stock, a shooter must release and reset the trigger between every shot, and any subsequent shot fired after the trigger has been released and reset is the result of a separate and distinct function of the trigger. All that a bump stock does is accelerate the rate of fire, causing these distinct functions of the trigger to occur in rapid succession. In essence, what the court is saying here is that that bump stock doesn't create an automatic set of functions that happen regardless of user input, but rather that the bump stock only accelerates what a shooter may be able to do with their finger alone, squeezing the trigger as fast as possible. The simple fact of a bump stock being added doesn't create a machine gun here. It doesn't change the nature, the base nature in which that semi-automatic firearm operates. So ATF, sorry, but your argument is off base here. The second main point that the court raised in today's opinion says a bump stock is not a machine gun for another reason. Even if a semi-automatic rifle with a bump stock could fire more than one shot by a single function of the trigger, it would not do so automatically. Firing multiple shots using a semi-automatic rifle with a bump stock requires more than a single function of the trigger. This point focuses on the fact that, again, even though the bump stock may allow more rapid fire through the harnessing of recoil against the user's shoulder and against that stock, which has a loose fit to allow it to slide back and forth, and it may accelerate the user's ability to fire compared to what a standard equipped rifle would be, each firing of that rifle, each cycle of the trigger requires a complete independent action. So in other words, I have a bump stock, I fire the first round. If I was to then release the trigger and step back or lean away from the stock, it's not going to continue to do what it needs to do. There's nothing automatic about the process. It requires that trigger to cycle every time a round is fired. One squeeze, one round fired. Again, compared to a fully automatic machine gun, one squeeze, as many rounds as it can fire until I release that squeeze. So the court is saying, even though it may speed things up, none of the functions that a bump stock adds to a rifle are automatic. In other words, they are dependent on the user continuing to cycle the trigger each time a round is expended down the barrel. So the third main point of the opinion today focuses not on the function of the firearm, focuses not on the function of the bump stock itself or a combination of those two things, but instead the government's argument based on a legal doctrine called the presumption against ineffectiveness, which essentially stands for the idea that that presumption weighs against interpretations of a statute that would render the law in a great measure nugatory and enable offenders to elude its provisions in the most easy manner. Essentially, this argument is saying that if the court would find against the ATF's position in this case, that it would effectively render the federal statute regarding the definition of a machine gun ineffective. In other words, we're taking all the teeth out of it, all the power, and allowing people to go out and make fully automatic machine guns through whatever means they feel are available to them, and essentially thumb their nose at what the law says. However, the court looked at that argument and squarely shot it down using the following language. A law is not useless merely because it draws a line more narrowly than one of its conceivable statutory purposes might suggest. Interpreting 5845B to exclude semi-automatic rifles equipped with bump stocks comes nowhere close to making it useless. Essentially, with that comment, the majority of the court is telling the government, don't be stupid. By excluding semi-automatic rifles with a bump stock equipped from the definition, in no way whatsoever are we making this federal law useless. You can still enforce it in the manner that Congress, not you ATF, determined was the appropriate way to enforce the National Firearms Act. So ultimately, the court has shot down the ATF's 2018 final rule on the bump stock ban. It is once again lawful to own bump stocks, to use bump stocks, to manufacture them, to sell them. We are again seeing a huge step in favor of the Second Amendment. And this is a big, big decision. This signifies, one, that this court definitely is taking seriously its role in evaluating basic human rights, which are defined in the Bill of Rights, which contains, of course, the Second Amendment, and saying that we don't have to put up with this kind of improper, unconstitutional rulemaking. And so with all the other cases that are going up in front of the court here this year and in the very near future, 80% lowers and frames, the pistol brace rule, things like that, we have a number of big issues coming up. This is a good signal that the court is looking favorably at the Second Amendment, looking at holding the government accountable for its decisions, and signifying that they're not going to just sit back and let the government roll over the people and roll over the Second Amendment, more importantly. If you have questions about this case and the ruling today, please feel free to drop them in the comments section below or reach out to me directly. All my contact information is available through the websites that are linked below. My email is also down in the link below. Please reach out, get in touch, and I'll be happy to talk about this opinion with you. If you haven't done so already, please consider subscribing to the channel. Would love to have you as a part of our community. Hit that like button, share this video. Let's get the word out to everybody so they know that, once again, if they want to own a bump stock, they absolutely can do so. It's a great day to be an American. It's a great day for the Second Amendment. I appreciate you spending some time with me here today, and I look forward to seeing you in the next video. Until then, Take care and stay safe.